sketching out the problem that we are facing. The Paris Agreement goal of holding the global temperature rise to 1.5 degrees centigrade requires annual renewable investments to triple by 2030. It requires no new investments in coal, gas, or oil, and it requires positively moving away from fossil fuels. Now, if you put those goals into the context of investor-state treaties and investor-state arbitration, we are faced with two specific problems. One might describe as an offensive issue, and the second one might describe as a defensive issue. The offensive issue is, how do we get to net zero using the investment treaty structure? Does it facilitate that? The defensive element is, how do we prevent investor-state treaties from stopping us getting there? And that is the only element that I'm going to focus on, which is the defensive element. And that is the very significant problem we are facing at the moment. The problem is as follows. We have, on the one hand, Paris Agreement targets that are requiring states to achieve certain goals. And on the other hand, we have a pre-existing investor-state treaty structure, a network throughout the world that imposes itself requirements on states to provide various guarantees to investors, and mostly will also allow investors to bring direct claims against states for breach of those guarantees or standards of protection. I want to just begin by tracing very quickly how we've got into this situation. Of course, just to fine-tune the point is that as states take steps to achieve the Paris goals, so they may well lay the ground for claims against them under investor-state treaties. So how did this mismatch arise? And this is a quick, broad brush and therefore inaccurate snapshot as how we got here. Investor-state treaties began in about 1959. That was the first one between Pakistan and Germany. It didn't include an arbitration clause. By 1965, we had the Washington Exit Convention, which brought into place a procedure for investors to bring claims against states. There followed a massive increase in these treaties. The treaties were designed to promote and protect foreign direct investment between contracting states. Nowadays, the current position, the estimate is probably around 2,600 bilateral investment treaties, together with a network of FTAs and regional agreements with investment chapters. Now, that whole network, which sets up guarantees and protections, was formulated, conceived, agreed, put in place without any regard to the climate crisis. There's no reason why there would have been any regard, because it predates the climate issue, or at least our appreciation of the climate issue. Investor-state treaties were dormant for a long period of time. Nobody really realized they were there. From the mid-1990s, lawyers woke up to their existence, and there followed an exponential increase year on year of claims. So actually, by early, the first rush were NAFTA claims in the early 2000s. And then outside of NAFTA, there were a whole wealth of different claims being brought under a wealth of treaties. And just a few weeks ago, ICSID celebrated the registration of its 1,000th case. With that expansion has come also what may be described as a pushing of the envelope in terms of treaty coverage. This is a function of clever lawyers and, to put it delicately, not so clever tribunals, or tribunals who are not so well versed in public international law. What we have seen is an increase in the coverage of treaties by virtue of an ever-expanding definition of an investment, what constitutes an investment. We have seen an increase in the scope of sovereign acts for which states are found liable. And we've seen an increase in the scope of treaty guarantees as lawyers and tribunals come up with ever-expanding definitions of what they cover. The result of that is that whilst this field might have been conceived of as a system of protection for good old-fashioned investments like construction projects and good old-fashioned state conduct like direct expropriation, nowadays it is very different. It is something of a barometer of world events, and it brings within its scope ever more sensitive areas of sovereign discretion, in particular now climate policy. So the result is that as states exercise their discretion and implement their climate policy, more and more we see claims against those states falling within treaty protection. And that runs the risk of massive claims against states, and it runs the risk of what's called regulatory chill, which is a disincentive on the part of states to actually realize their Paris commitments for fear that they will be sued and held liable with the result of very large allocations of their budget. Now, these claims are coming fast and they're increasing. And some of them now are absolutely directly on point. I'll give you one example, a case called RWE against the Netherlands. It's a case which began, and it has actually stopped, but it's a very good example. It's a claim against the Netherlands brought by coal industry interests. And their case was that the Netherlands' decision to phase out coal was in breach of an investment treaty, because at the time that the coal interests invested in the Netherlands, there was no indication that the policy would change, and phasing out fossil fuels would be phasing out their investment. And